Back live with you tonight here on In Focus, and thanks for staying on. Lawyers have warned that owners of aggressive animals should consider themselves legally liable for their pets' behavior. They further state that the arm of the law could go as far as touching properties if owners should plead poverty. The warning follows a spate of deadly attacks on children and yesterday's fatal mauling of an Eastern Cape woman on her way to work. Joining us now to explain pet owners' legal liability is legal expert Lufuno Musetsho of Musetsho Law Incorporated. Lufuno, good evening. Good to have you, and thank you very much for your time. What is the, what would you say, the legal recourse or a viable legal recourse option for victims? Sometimes victims, of course, are mauled to death, but they are loved ones who are remaining behind. Should a violent animal that they own attack one of their loved ones?
Very flexible. There are a number of remedies or recourse that owners, or not owners, but the victims of attacks have. What comes to mind is a very well-known principle, which is known as action de paupere. So this principle dictates that the owner of the vicious animals, in this case the owner of the pit bull, will be held liable for the conduct of his dog. So it does not only apply to dogs, it applies to all the domesticated animals. It may be a horse, it may be anything that is domesticated that you own. So if it causes damages to someone else, you are liable for that, and you can be sued for a number of damages. For instance, if I get attacked now as a waiting parent and I die, so the owner of that particular dog that attacked me is going to be sued by my kids for loss of support, because they will have lost someone who is supporting them financially. But if, let's say, a dog attacks a minor child who does not work, obviously you cannot expect anyone to go and sue the owner for the very damages that my dependents will sue the owner for. So, for instance, if it's a minor child, what comes to mind is suing for your funeral costs, for instance, or emotional shock. So those are the remedies that one have. And if I can go into the details, there are a number of things that one needs to prove. It's not just a matter of saying, hey, I'm going to court because, that dog attacked me. There are a number of things that the court needs to look at. And what comes to mind now is 4 elements that needs to be proven by whoever that was attacked by the pit bulls. And number one is that that pit bull must be domesticated.
Yeah.
In other words, there must be ownership. It must not just be a dog that is roaming around without anyone. So the ownership must be.
Seem to have lost that connection there to Lufuno as he is explaining to us broadly in terms of the problems that will arise in proving the case. Okay, Lufuno, I think we've got you back. Hopefully you are back. So you were still explaining what lies in proving the case and what would be important. First and foremost, you must prove ownership, right?
Yes, the ownership must vest with the defendant. The defendant is the dog owner. In other words, the defendant is he who will be sued should his dog attack somebody. And the plaintiff is the one that suffers the damages or that gets attacked.
Yeah. Now, in terms of cases where the owner did not give an instruction to attack, in fact, in some of the cases that we are hearing, the owner was not even there. The dog seems to have, in this case, in Port Alfred, eaten through the fence and gotten out. And they met this lady on the streets and decided to attack. How do you approach that case?
Well, I spoke of the issue of the ownership. So there are other elements that need to be proven, Sipo, that I do not want to go into them now because of the time. But you took me to another question, which is the remedies that the dog owner will have in case he's not available at home, yet the dog goes and attacks somebody. Let me just give you an example. The defendant or the dog owner will successfully defend his case if he can prove that at the time of the attack, his dog was being taken care of somebody else. What comes to mind is a dog sitter. You know, if you have a dog sitter and you know that your dog is inside the yard, inside the locked gates, yet the dog sitter allow it to go outside and attack somebody, you cannot then go to the dog owner and successfully prosecute the claim of actual depauperi against him, because he can raise a defense, a very valid defense, to say, at the time of the attack, the dog was with the third party that was in charge of the dog. So that is one of the remedies that is available to the dog owners. So if he is not available and the dog is looked after by somebody else, it's easy to just say, but you know, I have this and that who was looking after the dog. And I also spoke about the ownership, Sipo. It's very important to emphasize on this point, because if I am known to own a certain dog in the village and everybody knows that that is my dog, and upon it attacking somebody, I say, but at the time of attacking that particular individual, I had donated it to my nephew or I had donated it to somebody else. There is no way that one can successfully prosecute a claim against me.
So then the question becomes, what happens in instances where, for example, we're hearing in one of the cases, it's a child actually went to the neighbor's yard and was playing with the dog. So does that exclude the owner from liability to say, well, you actually came to my property, it could have provoked the dog. It was unforeseeable that the dog would react in such a way.
Thank you so much. So amongst other remedies or defenses that the dog owner will have is the illegal presence of the plaintiff in my house. So if I go to my neighbor's house illegally, let's say I'm trespassing, I do not have permission to go there, and I get attacked by a dog, I cannot successfully claim, under actual depauperi, because I was not there lawfully. So perhaps the question must be a bit broader, so that I may, when I answer it, I may know if the child was there lawfully or unlawfully. If the child was there lawfully,
how do you determine the lawfulness of a child being there? Because the child goes to the neighbor to play, and it does seem like it's a usual occurrence. It's not the first time that the child has been to the yard.
I'm glad that you mentioned the issue of provocation, Sipo, because that's actually one of the defenses that are available to the dog owners. If let's say the child is accustomed of going to the neighbor's house, but when he or she goes there, they don't provoke this dog. But on this fateful day, they provoke the dog, and the dog acted in a manner that it acted, and end up, causing injuries to the child. Obviously, one may raise a defense of provocation.
And ultimately, then, what are the kind of sanctions that are issued in this particular law that you are mentioning, the principle of exo di popuari?
So you want the four elements that I mentioned?
No, the sanctions. What are the fines? What could you be possibly looking at?
Sorry,
in terms of fines and claims that you can claim. You can claim millions.
I have already mentioned that you can claim for special damages. Let's say you got attacked by a dog, and all you sustained or all you suffered is just past medical expenses past medical expenses. So you can go and claim for the money that you spent at the hospital and the money that you spent with the doctors. You can also claim for disfigurement depending on the injuries that you sustained. You can also claim for future medical expenses. You can also, if for instance you were not working for 3 months because of the injuries that you sustained due to the dog attack, you can also claim for loss of earnings for that 3 month period from the owner of the dog.
Yeah.
So there are a number of things that one can go for. So if I get killed, for instance, and I have kids, my kids can also claim for loss of support from the owner of the dog, because the dog killed somebody who was supporting them financially.
Yeah. And under this principle of the law, you're saying you cannot claim poverty. So even if you're saying I am probably a pensioner now, I'm not earning any particular income, the law would still require you to make those payments. So I could possibly claim your house or your car.
Of course. If you have movables or immovables, those can be attached. You cannot run away from your responsibilities. And even if you have your savings, for instance, and they are known to the plaintiff, one can go to court and they will get attached. And we should bear in mind that if I get a judgment now, it will stay under my name for 30 years. So it's not a matter of I will just be reckless with my dog now because I'm not working, I don't have anything. You will have something one day and that judgment will follow you.
Lufuno, Musetsho, I appreciate your time. Thank you very much for coming on
Thank you.
Highlighting some of those issues. The legal expert Lufuno Musetsho, attorneys at Lufuno Law Incorporated, pointing out that important principle of actio de paupery that applies, which means that the owner of the animal is held liable for their actions.